Hello, you have reached the Hoonah District.
One moment, please.
Hoonah Court, Mary Kay.
Yes, good morning. This is Magistrate. I hope you didn't follow what I sent to your court. I supplied it to the other court, but I also sent it to the original court where the actions happened.
Yeah, I haven't done anything with it.
Okay. I'm wondering, since the judge is being rescued, Judge Nave, for the eviction hearing, that means it is both cases have been postponed. Then would be my understanding.
No, I don't know that.
I do, because once the judge is being reviewed, he may not oversee my hearings. Because
recused. The word is recused.
Recused or peremptory challenge. He's being rescued.
What? Recused.
Yes.
So I don't know that he has been. I haven't seen anything that says he has been.
Hold on, right here. Order of review of disqualification decisions. Defendant filed a motion to disqualify District Judge Thomas Nave in the above captioned matter, which is 1HN 1608. Judge Nave denied defendant's motion on December 5th, 2016. Per Alaska Statute 20.20.023, Ketchikan Superior Court Judge William Carey is hereby appointed to review Judge Nave's decision. Dated Ketchikan, Alaska, the 5th day of December 2016.
Right. So he's just reviewing that decision. There's nothing.
It doesn't matter. Once I already opened for him to be recused, he cannot be on my cases, because then he will try to show animosity or bias for me questioning his authority.
I'm not arguing with you,
well,
Eric.
I know what I'm
don't
saying. So
know. All I'm saying is nothing has been canceled yet.
Did you see what I sent over this morning, what I'm suing Esther for, and Daniel Meister and Eric? You're inflicting emotional distress upon me too, ma'am, by not understanding that I know the law. And
Eric.
Well, I'm just saying that's what everybody in the court's been doing. Denying me chemo, letting someone commit constitutional crimes, let people out of the courts. That is causing emotional stress because I do
Take a deep breath.
I have a high anxiety conditions already.
I know you do.
Now imagine what I've been put through. That is called
Slow down, Eric, slow down. Slow down.
Well,
okay?
I'm just saying, everybody's held accountable for that, ma'am. Everybody.
Slow down.
So therefore, I want something in writing today saying that there is no hearings on the 8th because I
know you do, but you have to wait until a decision is made, and nothing has been made yet.
When is that going to be?
You have to be patient.
I am not going to a hearing without a lawyer unless y'all intend to more incite and inflict upon me more emotional distress, because that's what y'all will be doing by not giving me any counsel. Just keep that in mind. I've requested for a lawyer, and I have not yet seen one. I have seen a judge violate Alaska statutes and Alaska Supreme Court rulings pertaining to eviction hearings that were opened illegally on court records. I've also seen judges attack me and ostracize me for my chemo, for my disabilities, which is called infliction of emotional distress. And then leaving someone on chemo with the court's knowledge is also aiding and abetting when they say they can't do nothing over a private citizen. I'm just trying to figure out my best recourse here, because without an attorney, y'all would be inflicting assault by means of emotional distress.
I'm not in a position to do anything, Eric.
Well, who would be? Because
you've already been told the answer to your attorney request.
No, I have not.
Multiple times.
Ma'am, do you realize you should look up Reyners versus Troop, 2015, in the United States District Court of Tennessee. There was a man last year appointed legal counsel for a civil matter, and he does have mental issues. He was appointed that because people tried to kidnap him and force illegal drugs upon him, like when you brought up why am I on a medication? Well, I have liver problems. My counselor will tell you I need counseling, not drugs, not medication. And that's what your courts have been denying me for the last 6 months because of C-sections.
Well, she exaggerates everything.
Because even on your record, she said there was an open civil case pertaining to a
what's she gonna lie about
pertaining to a criminal trespass hearing. Well, I was never notified of that. I was just given a letter by Eric Geddes. So there was no case. It was her boss writing a letter to me, which is shown on court records.
Right.
So how could you let her lie then? Because you as a judge would know she didn't have a case open. So why would you let her lie?
And I told her that.
Well, then why have I been treated this way and my matter not be reversed then? Because she committed perjury and a constitutional crime. And
because it wasn't based on that statement.
It doesn't matter.
Okay, Eric, I'm not going to argue the case with you, and I am not going to discuss this case, okay?
I do believe
because I just wanted to let you know that until you get a letter saying that their hearing has been canceled, it is not canceled.
I have a question.
So you will...
Well, I have a question. What statement drew you to the conclusion I was stalking her when I had weekly counseling appointments? I believe there's a thing called burden of proof and rules of evidence in this state, and hearsay is not...
I'm not going to argue this matter you
I'm just saying.
Over the phone. That is ex parte communication, and I refuse to do it.
How is it ex parte when you've recused yourself, ma'am?
I cannot do it.
You've recused yourself from all our cases, so it's not ex parte communication now. And I have that information from the chief of police that you recuse yourself from all our cases.
Eric, I'm not going to discuss the case with you, period.
Well, how do I file on court employees for causing emotional distress is what I'd like to
I don't know. How about me filing against you, Eric? I mean, you're causing me a lot of stress, too,
Thank
you know.
Thank you for threatening. You just threatened me. Thank you. I have that recorded, and that's going to be on my next blog. Have a great day, man.